2, 1. Hi, good morning, everyone. My name is Michelle Socker. I'm Director of Sponsorships and Special Events at the Chamber of Commerce of the Palm Beaches. Thank you for joining us this morning. We have a relevant program that is timely, that we think you will find very interesting, and it will be highly interactive. So I hope you've come prepared with questions for our team of lawyers from FordHarrison. All right, so there's 3 things that are going to happen today. The first is I'm going to go over some Zoom housekeeping that we have found at the Chamber are best practices for the meeting to go smoothly together. The second thing is you're going to get a chance to introduce yourself, and then I will introduce our speakers and we will move forward with the program. For handling, so let's start with Zoom housekeeping. All right, if you could keep yourself muted, that would be very appreciated. And if you do have an urgent question, you can electronically raise your hand in your box, or you can physically raise your hand and our speakers will call on you, and you can also use the chat box. So, but we are inviting you to physically raise your hand or use the electronic hand raise. All right, so now that's it. It's pretty simple for the Zoom rules. So now I'm going to move into introductions. So for your introduction in the essence of time management and respecting that for today so we get through the full program and get to your questions, if you could simply say your name, your title, and your company name, that would be great. And if we have time at the end to do more than that, we will invite you to do so. So let's start with an ambassador of the Chamber. I see Lisa Keller. So you can, Lisa, if you could unmute yourself. I just unmuted you. There you go.
Good morning, can you hear me?
Yes.
Okay, good morning, everyone. My name is Lisa Keller. I'm a financial center manager for Fifth Third Bank, located conveniently adjacent to the Chamber of Commerce in downtown West Palm Beach.
Great, thank you. All right. And I see Ms. Goldstein. If you could unmute.
Hi, good morning. My name is Felicia Goldstein, and I'm the District Chief of Staff for Congresswoman Lois Frankel.
Thank you, and I apologize. I should know better that it was Goldstein. I apologize. All right.
No worries.
All right, and Al.
Good morning. I'm Al Malafato. I'm a shareholder with Lewis, Longman and Walker Law Firm.
Great, thank you. And Kim. Kim, I'm gonna unmute you.
Sorry, I was on mute.
That's
I was
okay.
trying to find the unmute button. Hi, I'm Kim Ayers, and I'm with Lewis, Longman and Walker. I'm the Chief Administrative Officer there.
Great, thank you for joining. Marin. I'm gonna hit unmute for you. There you go. All right, Marin, you are unmuted. Okay. We're going to come back to them. All right, let's go to Steve.
Hey, good morning. Steve serves with Seacoast Bank, branch center manager in Okeechobee and Mill Farms, and also an ambassador.
Thanks, Steve. Thanks for joining. All right, Stuart. Stuart, I'm not going to touch your button. Sometimes I try to help and the person has unmuted themselves and then I unmute.
Yeah. Good
Sorry
morning,
about that.
Stuart Maslanic, Chief Financial Officer, Lewis, Longman and Walker.
Thank you. Thanks for joining. All right, I'm going to go back to Marin. You are unmuted if you want to introduce yourself. Nope. Okay. All right. So we're going to go ahead and get started. Thank you so much for introducing yourselves. our speakers and myself, we say we like to know who's in our audience so we can kind of tailor our presentation when we give one to them. So thank you for doing that. All right, so I would like to give formal introductions that are well earned about our presenters today. David Gobeo is a partner at FordHarrison. He focuses primarily on litigation. He received his JD from the University of Florida and undergraduate from Stetson University with honors. He is an active member of the Forum Club of the Palm Beaches, the Palm Beach County Bar Association, and has been an active member of the Associated Builders and Contractors for his entire career. I have the privilege of working with David on a regular basis because he's also a very prominent board member here at the Chamber, very generous with his time. And as you may not know, these webinars are actually done quarterly. So there is one webinar from FordHarrison every quarter at the Chamber, and they've been doing them for how many years, David, have you guys been doing quarterly webinars?
Many, many years.
Many years. Well, we're grateful. So thank you. And their topics are always hot topics and timely. All right. And he's also been named a Rising Star by Super Lawyers Magazine from 2012 to 2019. All right. Our second speaker today, joining him, is Matthew Luttinger. He's an associate at FordHarrison who focuses his practice primarily on litigation and compliance. He received his JD from the University of Miami with honors and undergraduate degree from Florida State University. While in law school, he served as the articles and content editor for the University of Miami International and Comparative Law Review. All right, and our third speaker joining them from their team is Ari Hernandez. She is a counsel with FordHarrison. She received her JD from the University of Florida and her undergraduate degree from Florida International University with high honors Phi Beta Kappa. She devotes her practice to helping employers navigate litigation, investigations, and day-to-day employment issues. She was named a Rising Star by Super Lawyers Magazine for business litigation in 2010, prior to becoming in-house counsel for 2 engineering companies with multi-state operations. So David, Matthew, and Ari, welcome. Formally, thank you for sharing your time and talent with us. This is certainly a hot topic today. So with that, I am going to start the PowerPoint presentation and hand it over to you, David. All right.
Great. Thank you so much, Michelle. While you're loading that up, I'll start talking. Like she said, my name is David Gobeo, and I'll be presenting along with my colleagues, Matt Luttinger and Ari Hernandez. And I apologize that Christine Hanley wasn't able to make it this morning, but like she always says, we really appreciate when you give questions to us, engage in the presentation. If you're going to be giving a topic that is pertinent to your business, make sure to put it in the form of a hypothetical question. We don't want to waive any kind of attorney-client privilege that you may have, but hypothetically speaking, or I have had this friend who had this happen, that's perfectly acceptable. The questions can be off topic, but we really do welcome questions. It's a helpful way to go through what we're discussing and kind of flesh out some of the issues. Some of the ways of dealing with harassment are not always black and white. So you got to look at them at a situation by situation basis. We're going to be talking about why this is so important right now, how we got to where we are, and what the federal government and state governments are doing in response to harassment. And then we're going to finalize with going over what your legal obligations are and how to handle these situations. So I will turn it over to Matt now to get us started.
Thank you, David. Good morning, everyone. Thanks for joining us today. So I'm going to start with where we started, and then later on we'll talk about where we're at now and how to go about things now. So before the MeToo movement, companies focused only on avoiding liability. Oftentimes training was limited to management, and the approach was knew or should have known, meaning if I didn't know about the harassment, then it wasn't happening. And it didn't really prevent it from happening because it would happen, but because people had their head in the sand, it wouldn't do anything. And the thought process was educating employees only teaches them how to sue us. Next slide, please. In 2017, the paradigm started to shift after the Harvey Weinstein accusations. At least 87 women brought allegations of harassment and abuse on his hands. Ever since then, the MeToo movement has started, and we'll get into that further. Next slide, please. Despite the MeToo movement, a recent study has shown that despite 81% of women and 43% of men reporting sexual harassment, only 2% of men and 1% of women said they had actually harassed someone. Very few people have ever been accused of sexual harassment compared to those who actually said they experienced it, which shows that we still have a problem with the reporting aspect, and if I don't know it happened, it didn't happen. Mentality is still commonplace, and that includes the workplace. Next slide, please. According to the Wall Street Journal, these are a couple of reasons that women have said for not reporting harassment. The most common reason is, I didn't want to create a fuss, look like a troublemaker, or get a bad reputation. Another one is feelings of shame or shared blame. Reporting, it doesn't result in any action, and fear of retribution. Next slide, please. So these are a few jury verdicts from 2019 showing the amount that a plaintiff could possibly be awarded for a sexual harassment type case. So Alki David is a billionaire production company, and he had a couple lawsuits against himself and his companies back in late 2019. One resulted in a $58 million verdict. Another one was a retaliation claim against Three Rivers Provider Network. And in that scenario, the employee had reported the sexual harassment, and then the jury determined that she was terminated as a result. So companies have to be aware of not only preventing and doing things to accommodate the employee after the harassment has occurred. The employer has to be aware.
Did Matt freeze up there?
Am I frozen?
I can see you now. Maybe it might have been my end. Go ahead.
Okay. Next slide, please. So I'm going to go through a little hypothetical to show where we are today, and to give you a little preview of the hypothetical. This is going to be a conversation between a man and a woman, and assume she's already had 2 drinks. Next slide. So here's the conversation. The man goes, "Mind if I move in closer?" Woman goes, "You're very pushy, you know." Man goes, "I like to think of it as opportunistic." Woman says, "The answer is no." Later, after additional efforts at persuasion, the woman says, "Okay, fine, just another drink then." And the man says, "That took a lot of convincing." Next slide, please. If you have your camera on, you can raise your hand. If not, don't worry about it. But I want you to think, I want you to answer these 2 questions. And remember, alcohol is involved. How many of you think that this was just flirtation? And the other question is, how many think the man was too pushy or maybe creepy? And perhaps the dialogue should have just stopped with no. Next slide, please. Some of you may notice that this hypothetical actually came from a well-publicized debate from 2018. These lines are all from the famous song, "Baby, It's Cold Outside," that originated in the 1940s from the movie Neptune's Daughter. And since then, a lot of radio stations have taken it off the radio. It was removed from the top 10 most popular songs during the holidays. And this was just the beginning of things changing in this type of realm, and people acknowledging that a lot of these things, while you didn't realize it at first, were inappropriate. Next slide, please. And here's another picture showing has continued. This is the Sarasota unconditional surrender statute, and you can see that there were people who put MeToo on the leg of the woman, and the actual whole statute shows a woman kissing a man. He's a sailor returning from World War II, but later on it's come out that actually this was not a romantic type kiss, that this man had just met the woman, and she claimed that he actually forced himself upon her. So a lot of these romantic type things, like the song I just mentioned, the statute, it's now come out that they're not really romantic. They're demonstrating that there's a whole thing where no one talks, the women don't talk, and everyone pretends like things don't happen. And now you're starting to see women talking more, and as a result, lawsuits are forming, and companies are on the hook for these actions. Next slide, please. So here's a couple of examples from what I was just talking about, different things that have resulted from these MeToo claims. And not only in the employment context, students have been expelled from colleges for claims of sexual harassment. You can see a couple of these people here, famous actors. James Franco is one of them. Some of these people have been able to rebound from their careers, but others have not been able to get new acting roles because of these claims. You have security fraud, class actions, and shareholder derivative suits. These are a little harder to prove, but it shows that you're not only have liability from employees, you can get lawsuits from shareholders and investment holders, claiming that the value of the company was harmed by the board of directors failing to accommodate these issues. So how should one balance these different perspectives with all these competing interests? You have to look at everything from both sides and weigh the positives and negatives, and make the best decisions as a company. And these forthcoming slides will show how to do that. Next slide, please. I'm gonna turn this to Ari now.
Good morning, everyone. My job is to talk about the evolving landscape because of these rapidly evolving standards and new expectations in the workplace with respect to sexual harassment and claims of sexual harassment. And I'd like to tell this really quick story about a case that I tried 3 months before the Harvey Weinstein story broke. It was a very powerful entertainment company that I represented who recently put a woman as their president, and one of their very successful senior executives who had been in the industry for over 40 years was a typical, oh, you'll never work in this town again type, who treated his publishing assistant extremely poorly, made awful comments to her concerning her pregnancy and other things. The president took over the helm of this company and said absolutely zero tolerance to this type of behavior, and terminated him. He was employed under a contract that allowed termination for cause, which is a lower standard than what is applied to sexual harassment claims in the courts, which is severe and pervasive, and we're going to be talking about that. The client, in this case, was concerned that these comments, as bad as they were, would cause a judge or a jury to roll their eyes. Is it material enough that we can terminate him for this? And even though the standard here was simply cause for termination, I lost. Had we brought this case and had this case been tried 3 months later, I believe that the standards have evolved so rapidly and far outpaced the standards in the courts that we would have won. That I think that it would have been cast differently. Even a judge who was, you know, a senior judge, and I expected to be more reasonable in terms of his contract interpretation. Frankly, that's what the case wrote on. At that time, it was still reflective of the old standards. However, in this case, companies now have quickly realized, I think part of the MeToo issues is the publicity that the hashtag MeToo caused. So many companies are voluntarily coming to us, our firm, and saying, we want to take voluntary measures to, you know, make sure that we have a work environment that is free of harassment. And part of this is ending forced arbitration of harassment claims. And as a matter of course, you know, we used to advise our clients to have arbitration agreements where you'd have to bring single arbitrations for your claims. And, you know, in my experience, arbitration tends to be just as expensive and just as cumbersome most of the time. But there, you know, there are still benefits depending on your business in terms of whether you want an arbitration clause. But this started, the elimination of arbitration of sexual harassment claims started with executive orders and regulations in the government contracting space. And as you're seeing, we're seeing a lot of initiatives, executive orders and regulations in the federal government that apply to government contracts are trickling into diversity initiatives, you know, quota type systems, quantitative analysis of your diversity, and they're also trickling into state legislation to the private sector. So we have people, you know, we have companies, you know, where Google, Uber, Microsoft, those companies are taking these voluntary measures and coming to us, not just with respect to ending forced arbitrations and other like legal measures, but also culturally, how we can have diversity training, increase our diversity at the senior management levels, with the thinking that in doing that, you will create a more equitable environment. I think also I'm seeing a lot of more robust investigation protocols, and I think David will speak a little bit about this later on. When you do get a claim, so many times, even if the claim itself has no merit, the way you handle it, so many of these cases are won and lost in the mishandling of the claim and in anything that's happened subsequently that can be perceived as retaliatory. And now we're seeing more and more companies opting for termination instead of lesser discipline. It used to be the case, and I was in-house counsel for a company, and you know, I've been litigating now for a long time, where somebody brought a claim, and depending on how valuable the person accused was to the company is how much you paid out and got a non-disclosure agreement and got the person to just go away as quickly as possible, no matter how expensive it was. Now, partly again, because of the threat of publicity is more real. And I think people just are evolving in terms of their company ethic, that, you know, and companies are now seeing, you know, showing people the door much more publicly and announcing much more severe sanctions and less tolerance. Next slide, please. We also have to understand that there are unintended consequences of this movement, and that might be detrimental, and you might monitor your company for this. I know somebody who, because of sexual harassment or any type of fear of those claims, was in a senior management position with a company and wasn't allowed to travel with the male executives. And that in and of itself is sexual discrimination. So there's, you know, there's an issue here, because where I saw with my client, the moment a person was in real power, a woman was in a real position of power, there was all of a sudden less tolerance for something that had existed in the entertainment industry and had been tolerated for years. And she said no more 3 months before the Harvey Weinstein case. So we need to, you know, make sure that and I've been very lucky in my experiences with the people that I've worked for in the legal profession, where they've always created opportunities, and when they saw roadblocks because of either in whatever sense, they've always tried to remove them. But similarly, as a lawyer, I've seen it happen with my clients where they're so concerned about the interactions now between female employees. And it's not just females in the sense, we're also seeing same-sex harassment cases here quite regularly now. So we can't be thinking in that binary and that dichotomy anymore. We really need to create a culture that appears and is equitable and more safe. And I'll tell you why in a second. Next slide, please. So as attorneys, we usually give legal advice, but it always comes with moral choices and practical choices. And, and in this case, I find that, and it's hard to convince people on something so abstract, that the culture and morale issues in your company really will color how your company is perceived if a claim is brought, and oftentimes even pushes somebody to bring a frivolous claim and thinking that, oh, I was treated poorly because, it's like the way you do business will definitely color the perception. I saw recently a memo sent to women in one department, and every time the memo starts off, it leads off with girls. That's something that even if there's no sexual harassment in that environment, it just looks like, I also there was another case, not at this firm, where again, no sexual harassment, no sexual discrimination. It was completely false allegation. However, there was one flippant comment by a supervisor to an employee when she said, okay, I'm going to, I have to tell you something. And she's like, oh, don't tell me you're pregnant again. This person had come from maternity leave. The company had allowed her to take the maternity leave, no problem, would have happily done it again. She was employed for nearly 2 years after she took her maternity leave. But it was this one comment from her boss that, perhaps, and he was also a jerk boss, just made her bring this claim. And all of a sudden you have this one comment that creates a different standard of discrimination, because here you have now direct evidence of discrimination if your boss says, oh, don't tell me you're pregnant again. Next slide, please. So we're seeing all these weird attempts to kind of regulate employers' behaviors. And one of these is just what I find a bizarre provision, is this Tax Cuts and Jobs Act, which denies deductions for confidential settlement of sexual harassment claims. Basically forces employers to choose between whether, non-disclosure and non-deductibility of settlement payments. But this legislation does not take into account what the accuser, what the complainant, what the victim would have wanted. What if she wants confidentiality? Next slide, please. As I mentioned earlier next slide, please. As I mentioned earlier, hold on. As I mentioned earlier, a lot of the federal response begins in the government contracting space. Under the Obama administration, we saw government contracting regulations with respect to diversity and also with respect to outlawing arbitration of sexual harassment claims. And, I'd like to remind everybody now that with respect to a person bringing a sexual harassment or claim with the EEOC, you cannot prevent in your settlement agreements or separation agreements them from bringing a claim. However, you can prevent them from monetary recovery. So, if you're entering into a separation agreement or into some kind of settlement agreement with a client, make sure you monitor those provisions in your agreements. Next slide, please. So this is a quick hit of the different types of legislation that is just now popping up all over the country, and it's varied. We are now seeing states outlawing arbitration for sexual harassment, following the lead of the federal government. Also, certain confidentiality agreements requiring older workers benefit protection act type language, which I'm giving you 21 days to consider this and 7 days to revoke the agreement if you sign it. There are now states that require annual sexual harassment policy and trainings. There are states that have expanded employer liability to non-employees. So if I have a vendor harass me and the company allows this to continue, then all of a sudden now there's employer liability in that scenario. We have pushes to increase damages caps under Title VII and the state counterparts of under the, like, for example, the Florida Civil Rights Act caps punitive damages at $100,000. And, many say that that's outdated. If you put that cap up against a company like Google or Uber, what is it? It's just a slap on the wrist. So we're dealing with pushes to increase the damages caps and also even create personal liability for the harasser under these state legislations. Also, there's issues with changes in the burden of proof. And I'm going to talk about this a little later because this is, we're seeing a change in standards. Whereas before we had a severe standard under Title VII, which standard was adopted by most of the states, we see that California now can premise a claim, a plaintiff can premise a claim on a single incident for hostile work environment. So here we're also talking about non-disclosure agreements, and many states are now eliminating or nullifying non-disclosure agreements by employees that are as a condition of employment. That means I sign an agreement where I cannot discuss anything that's going on at work, not just trade secrets and confidentiality and things that are usually confidential business information, things that are usually the subject of non-disclosure agreements. These non-disclosure agreements also say, okay, I can't say anything bad about the company or talk about anything that happened there. Those are, I foresee that many of those are going to be stricken down as against public policy. But this, again, doesn't talk about non-disclosure agreements in the context of settlement. I don't think that women or anyone for that matter, the vast majority of people do not want to be the poster children for eternity for sexual harassment. And I think that there's a real danger here in that many states will eliminate or prohibit non-disclosure agreements in all aspects of in the sexual harassment settlements and force them to be public. Much like, for example, claims for overtime have to be approved by a court, and many courts are now forcing overtime settlements or settlements of overtime claims to be actually filed in the court system. And jury trial waivers similarly, where we try to as employers, you generally try, or sophisticated clients, even in a business perspective, you try to get jury trial waivers inserted into your agreements just to eliminate that variable. Again, no rehire clauses in settlement agreements. And also, very important is something I'm seeing a lot of reforming of evidentiary rules. Whereas in the past, I had a case where a woman sued her employer, again, a very frivolous claim for sexual harassment. And she went off to work at a subsequent employer that was an interesting establishment where patrons were beaten with sex toys, and that might have woken everybody up. And the drinks that she was serving had the most just blush-inducing names. And that kind of evidence typically in the past would have been allowed in court. Now, because of these evolving standards, what a woman or anybody does outside of the workplace is more and more being regarded as irrelevant to what is proper in the workplace. Next slide, please. So with respect to this cultural shift, and these are my last 2 slides before I hand off to David, we talk about difference in generations, and are the baby boomers really the eye roll people, the people that would have said, oh, he said that, oh, come on, get over it? That was a real concern in this case, in the case that I discussed at the beginning of my presentation. But similarly, I think everybody needs to be approached not just with respect to their generational and kind of pigeonholed with respect to what their generational assumptions are, but also, like, for example, I know somebody who sends the most innocuous messages. I've known this person for 25 years, but every single text message he sends has a winky face emoji after it, which immediately turns that text message. I mean, he's almost 50, so I don't think he knows that it immediately turns that text message into something creepy. So I keep telling him, stop doing that. And there's actually companies that have outlawed the use of emojis in their company communications because it can be misinterpreted. How are you doing? I'm doing fine. Wink. I mean, what is that? So I think that the perception that somebody, because of their age or their generation, isn't savvy is dangerous, but by the same token, we can't ignore real cultural differences, which brings me to the Gen Zers. Please, next slide. Next slide, please. People say, well, these people, they come into the workplace, they are listening to all these vulgar lyrics in pop songs. They don't know how to behave in the workplace. I disagree. I find that Gen Zers are more liberal in the sense of what they expect they're able to do outside of the workplace and not have to worry about it affecting what they do. And there's so many laws now that prohibit employers from considering, in various states, legal off-duty conduct in whether, to terminate an employee. So in this case, I think, Gen Zers really understand that what is inappropriate outside of the workplace, or what is appropriate outside of the workplace, is inappropriate inside of the workplace. And I think here we are going to see a change and as mentioned before, in the severe and pervasive standard. Perhaps the courts will lag behind in articulating a black and white, black letter law standard as to what is severe and pervasive. But I think we need to be mindful that we might get in front of a jury of Gen Zers or millennials who are used to growing up with this messaging that sexual harassment is not acceptable, that even minor transgressions are you are able to penalize them severely, that that men and women are equal, that also that there isn't this gender binary. So I think we have to be very mindful of how things are going to play out to a future jury as we approach our employees, as we conduct our, as we write our policies and as we conduct our discipline and our investigations. Because what is severe and pervasive to, somebody that would have rolled their eyes at my, entertainment industry case is not going to be the same standard that might, that a 30-something or a 25-year-old might apply when sitting on a jury. So with that, I pass that along to David, who will provide you with some more concrete tips on how to handle sexual harassment claims in the workplace.
Thank you, Ari. So in my experience, I've had mostly female bosses and always worked in employment law. So everybody was very hypersensitive in their language. But before I went to law school, I worked in IT and at an insurance company. And I remember approaching a woman who she had her computer was on the floor, a floor type model. And I said, excuse me, I need to get onto your desk to fix your computer. And her response was, oh, just what I wanted, a man under my desk. Was that, so what do you think? Was that comment harassing? People nodding their heads. Yeah, thumbs up. Well, one of the components of harassment is the comment unwelcome. And so when I was in my 20s, did I want a woman inviting me under, making extra comments like that? Maybe. But part of what Ari's talking about with the evolving standard is what does a person individually consider welcome, or what would be reasonable for a group of people to consider what's welcome. And courts have historically, this has shifted over time, but historically they did give some leeway depending on where you work. So if you were in a construction yard, rougher language was expected and tolerated by the courts. And that same type of language would not be tolerated in an office setting. And I think we've already started to see cases where rougher language is not being as tolerated in a construction environment or something like that. And the biggest change that I've seen has the other component of harassment, severe and pervasive, was the conduct so difficult that it affected your job. So a woman making an offhanded comment to me on one occasion certainly wouldn't affect my job. That wouldn't be severe and pervasive. And the standard is very high. It involves, courts have found cases where there's dozens of comments and even some touching, a slap on the butt, to not be severe and pervasive. Not everybody might agree with that, but that's historically been the case. I have seen changes now at the appellate court level where even one incident, depending on the severity, can be enough to get you over that line. So even though there hasn't been much change in the federal law, and we certainly haven't seen much in Florida from a state court perspective, the judicial decisions, I think, is where we're going to see a lot of that evolving. All right, so Michelle, can you go to the next slide, please? One of the things that you really need to focus on with your business in trying to combat unlawful harassment is creating a culture that starts at the top. That's opposed to harassment, that deals with problems. So obviously you want to set clear expectations. I expect everybody on this call today has a written policy, and if you don't, that's absolutely necessary. So that should be step one before the day ends today. But probably more likely you have a written policy. Maybe it hasn't been looked at for a long time. So you want to make sure you revisit it and make sure it's up to date. You want to make sure that beyond your written policy, you're holding managers accountable. It really does start at the top. Even high-level executives, they need to have this same understanding of what's expected and what's required. Ari had mentioned diversity training as really starting to grow this year. I think that's a great idea. Because that is a great way to get a buy-in from the people at the top. I know I was called in to do an investigation with one business, a medical practice, and they had me sit down with this one doctor who was a relatively young doctor. I believe he was younger than me. And so I said, your employees are complaining you said this. And so I did say that. And so why would you say that? Because he didn't understand that his comments could be considered offensive. He didn't understand that they were unwelcome comments. So first of all, explaining to him, okay, these comments that you said are unwelcome is the first step in the process. And then explaining to him what the consequences of continuing to speak like that would be, the potential legal liability, the lawsuits, the jury verdicts that Matt went over at the beginning, the cost to the business. And that's just the legal side. That's not even the practical side of morale and turnover and those other kind of things that you have to deal with. But in addition to holding managers accountable, all levels of employees need to be held accountable. So what do you think about the circumstance where a subordinate, say a subordinate male, is texting his female boss explicit text messages, explicit pictures? See any problems with that circumstance? He's not the manager, though. He's not the boss. But yeah, absolutely. I mean, yes, I see some nods and thumbs up. Right, that's right. I mean, it seems pretty clear. Conduct by a subordinate needs to be held to the same level, the same standards. And the problem you could run into in that circumstance is one that Matt had mentioned, which is where the subordinate is sending inappropriate things to his manager. The company maybe deals with it, doesn't deal with it, but any action taken against the manager at that point, if she complained, might be considered retaliatory. So in addition to doing an investigation, solving the problem, it's really important to monitor the potential discipline against the person complaining, whether it's a manager or a subordinate. Retaliation is just as big of a concern as the underlying harassment. And I think Matt had made this point as well, that, or Ari too, there may be absolutely zero foundation for a finding of harassment. Or maybe it's a personality conflict. Maybe it was an offhanded comment. But what the actions against the person complaining after the fact is what could be more of a potential problem than what was complained of. Okay, can we go to the next slide, Michelle? So your policy should address offensive comments, not just about women, but about any kind of person. And Ari had said it's not just binary. It's not just men and women. It covers a large range of things that can be harassing. The MeToo movement has really put a focus on sexual harassment, male, female. But harassment can relate to race, it can relate to religion, it can be any protected category that somebody's being harassed about. So it's not just sexual jokes, but religious jokes. Pornography has been a problem for a long time since we've had a digital workforce. Females, males rating employees. These could be problems. What I tell you I've seen has been a problem is somebody who uses a lot of rough language in the workplace. So if you have a boss who swears a lot, it's not illegal to swear. It's not against the law to curse at people. And it's also not illegal to be an asshole. And if you treat everybody, equally horribly, you're not violating, you're not treating people different on account of their gender or sexual orientation or anything like that. But it's going to lead to claims. And so, one of the more recent hypotheticals that have come across my desk would be a boss saying, suck my you-know-what, or, you're a derogatory term for this sexuality. And he wasn't using it in a sexual way, wasn't treating anybody differently. Everybody got the same treatment by this person. But that type of language in the workplace is what leads to claims. And so that's the kind of culture that you don't want in your workplace and need to deal with. All right, so you want to go to the next slide, Michelle? Audit policies and procedures. So I had mentioned this. Now is the time to look at what you have written down. And Michelle, if you want to go to the next slide, that'd be great. You want to make sure that your policy clearly defines what sexual harassment is. Give some examples of conduct that's not allowed by your business. You don't want it to be too much legalese. Like I said, you do want it to be easy to understand. What we and Ari had kind of gone through, I think, the difference between on-duty conduct and off-duty conduct. Generally speaking, you're regulating your employees in the workplace and their on-duty conduct, but considering what's going on in the world right now, everything could be on-duty conduct. Or people are working from home, people are texting and Zooming and messaging all hours. So the blur between when work ends and when work begins is difficult. So in Florida, there's no regulations against off-duty conduct. If you take discipline based on off-duty conduct, generally speaking. So that does need to be a part of something that you look at. Social media policies roll into this as well. So the slide says compliant with state local law. Does it address same-sex sexual harassment? Well, you probably know that the Supreme Court ruled this year that Title VII of the Civil Rights Act also covers sexual orientation. So you're most of you are Palm Beach employers, so you probably have that in your policies already because it's a county ordinance. But if you don't, you need to update it. And part of the problem will be you must have a policy to protect your business to make a defense. And I'll take a quick step back here to explain why. There was a Supreme Court ruling nearly 30 years ago, actually involved the city of Boca Raton. One of them did, that said, if there's harassment in your business and it's brought to your attention, you need to do an investigation. You need to solve the problem. And if you've done that, you have an affirmative defense in court. So yes, somebody may have been harassed in your workplace, but you won't be liable for it because you did these things. So this is the main takeaway here of the part that I'm talking about. This is how you deal with the problem and how you protect your company from liability. You receive a report of harassment, you investigate it, you do something about it, and resolve the problem. And we'll kind of go over the different scenarios. And if you have a question about a specific scenario, feel free to jump in or put it in the chat. But your policy. So the reason I got on that tangent was because if your policy doesn't have one of these protected categories, and then you present your policy to, say, the EEOC and say, we met our requirement because we have a written policy, it's understood by the employees, and we investigated the problem, there's going to be a glaring omission of that protected category. So if you don't have sexual orientation, you're going to say, well, you have a policy against harassment, but you omitted sexual orientation. Or a lot of times, for some reason, I see age is not in the list, and that's the type of claim that we happen to have. So, not that it has to be completely inclusive, and you can't have catch-alls for local ordinances, but to the extent possible, you want to make sure it's up to date and covers the categories. No retaliation. Sometimes you want to break out your retaliation section to make clear that people won't be retaliated against for bringing something forward. And like I said, even if it's something that you find to be unfounded, you want to ensure that there's no retaliation taken as a result. Next slide, please. So in terms of confidentiality, you want to make clear that, as part of a full investigation, you need to discuss what's being claimed, and you need to find out whether it's true or not, or whether you believe it's true. So you can't guarantee absolute confidentiality in these investigations. You have to say, we'll handle this as discreetly as possible. It will tell as few people as possible. But you need to confront the harasser. Did you say this? Did you tell this person? Did you touch this person? So it's not going to be confidential. That's how you fully investigate. The complaint process, that should be in your written investigation, and it should make clear who do employees complain to. You want two things that are really important in this part of the process. You want that, obviously they need to know who to complain to, but usually it's their direct supervisor or manager, but they need to have an alternative to go to. So if their supervisor is the one harassing them, they need to be able to go to the manager, or if the manager is the one harassing, they need to be able to go to human resources. And then the second thing is, you don't want to make too many people in that list. 2 is usually the right number. You usually bring concerns to your direct supervisor, or bring concerns to human resources. Depending on the size and structure of the organization, a better option may be bring all complaints to human resources. If the HR person's the problem, bring them to the CEO. Part of the reason for that is if you have too many people that it can be reported to, somebody might drop the ball. Somebody, maybe they didn't have proper training. Maybe they say, oh, this was off the books. They didn't really want to, this wasn't a formal complaint. They say, I don't want to make a formal complaint, and so they didn't do anything with it. Well, your HR people should know that that's a complaint that needs to be dealt with. And so by directing people through your complaint process properly, it'll help avoid some of those issues. A prompt, thorough, and impartial investigation. So sometimes investigations can take longer than a day or two. I'm sure you deal with it right now with your employees working remotely, or people who are in other states, or dealing with people who are out of town. You can't always talk to everybody right away. So you want to get through it promptly, but that doesn't always mean immediate. It's okay if it lasts a few weeks, but make sure it's thorough. Make sure the people who are identified as witnesses are talked to. Make sure you obviously speak with the complainant first. Any witnesses they've identified and the person they're alleging harassed them. And your policy should also state assurances of prompt and appropriate remedial action. Next slide, please. Another component of being able to make your affirmative defense is that you have a clear policy that's distributed to your employees. There's a number of ways to do this. The old way was you give them the packet on the day of hire and they sign the acknowledgement, I received your policy. That's harder to do these days. Digital signature is just fine. Checking a box on your intranet is just fine, but you want some type of audit, some type of acknowledgement that the employee has received your policy. And you should be giving it to all new hires. I would certainly consider periodic. I would recommend companies be doing training at least once a year, and that's the perfect time to distribute the policy again and have them sign it again. Next slide, please. Training. And you can go to the next slide. So you have a number of different options in terms of training. It can be handled in-house. It can be handled, you can have employees watch a video if you need, or just do something very informal. If you've updated your written policies, have a meeting and redistribute them. But it makes sense to ensure that your managers understand what their obligations are. So if somebody comes to them and says, look, I don't want to make a formal complaint, but so-and-so made these comments to me, they need to understand that that's a complaint and needs to be dealt with and reported and investigated. And so that's why training is important. Having these kinds of discussions with your employees, it's the same kind of things that the discussion that we're talking about right now is what needs to happen, and both with supervisors and with employees, because employees need to understand that they need to report concerns and how to report concerns. You want employees to bring these concerns to you, because if you're able to deal with them, then you can meet your affirmative defense. Then you can avoid liability. If you don't know about it, if you keep your head buried in the sand, then the person's going to get fired or claim constructive discharge, and you didn't have a chance to solve the problem. So that's why training is important. That's why diversity training is important. It encourages people to bring issues to your attention so that you can deal with it. And by you dealing with it, you're avoiding liability. Next slide, please. And, I'll tell you, part of who you're protecting your employees from can be pretty broad. What do you think? Would a company have any liability to do something or any obligation to do something if a contractor grabbed one of their employees' butts? What do you think? Well, that's not their employee, so what are they going to do about it? Well, the point of where I'm going here is that it is possible for an employee to bring a claim of harassment based on conduct from outside vendors. It's a higher standard, it's a more difficult claim, but it does exist. So one hypothetical that came across my desk was a doctor who was not an employee but a contractor grabbed the butt of a nurse, and the nurse was an employee. So, when you look at it from our legal defense perspective, like, all right, it was one incident. This person wasn't our employee. She reported it, and we gave the doctor a talking to. We gave him a very stern verbal discipline. Don't do that again. And this was pre-MeToo, so maybe that was good enough, because from our legal obligation perspective, we solved the problem. He never did it again. But today, that kind of circumstance, it might not look like we took prompt remedial action by just sitting down and talking to him. It may need to be more formal than that, and more extensive than that. Okay, so yeah, we just got a comment that your company had 13,000 employees complete harassment training through LinkedIn Learning, and it was easy to use and informative, and that's great. That's definitely been the trend. A lot more companies are wanting to do it digitally and online, and asking us to do it in that format. One of the things I like about this format is people being able to ask questions. Oh, well, if somebody said to me, what if I said to one of my female employees, nice shoes? Is that harassing? How could somebody consider that harassing? And it gives you the chance to open up the dialogue and discuss. what some people would interpret to be harassing, what some people wouldn't interpret to be harassing, what's appropriate approach in the workplace, and it allows people to think about it. But a digital format is a great way to get it to a broad number of people quickly and inexpensively. So it's definitely helpful. All right, next slide, please.
David and
Yes.
Ari and Matthew, I just want, and our guests. So just so everyone knows, it's 9:29, just turned 9:30 on my iPhone. So our guests are welcome to stay. And I know you have a couple slides left, but I do want to, also, if somebody has, a hard stop at 9:30, you're not being rude to leave the call. So you're welcome to leave the call and go on with your day. And we thank you for joining. So with that said, David, go ahead. Just want to respect everyone's time. So it's up to you how you want to proceed. You're welcome to finish your slides. Okay, great.
Yes.
All right.
I can speak quickly, and we'll send the slides out to everybody that kind of go through. And I'll try to summarize quickly. And my apologies. I don't want to take up too much of your time, but this is the real important part here of what happens when somebody brings a complaint, the investigation. And so if you look at the next slide, you'll see there's a number of questions that you want to ask. Who's going to do the investigation? How is it handled? Are you looking at their employees' past? And then you can go to the next slide. You want to make sure that the investigation keeps moving, that you keep discussing with people, that you get to the end, and then you can go to the next slide, Michelle. You want to make sure that you document what you're doing in the investigation. That's very important from the defense side, from your employer side. When presenting our circumstances to the EEOC or to a jury, we want to show that we did the investigation. We talked to the witnesses, we talked to the harasser, we determined something did happen, something didn't happen, and that was well documented, who we talked to, when we talked to them, and what was the result. That's the key takeaway from the investigation. Now, you don't have to be CSI. You don't have to prove beyond a reasonable doubt what happened. You weren't there. There weren't cameras on. It's what you believe. So if you believe that somebody did not engage in wrongful conduct, you don't have to fire them. And if you believe that somebody did engage in wrongful conduct that merits termination, you can fire them. It's what has your reasonable belief based on your investigation. That's the important takeaway. And you can go to the next slide, Michelle. And Ari had mentioned you don't have to fire somebody because they made a wrongful comment, but if you don't do something that solves the problem, you're going to be held liable. It's remedial action. You have to solve the problem. That's the key. So maybe moving employees into different departments, putting somebody in a last final warning, suspending them. You have a lot of options in what you can do in wrapping up an investigation of harassment. And then where you don't find harassment, it's best to give the employees your policy, have everybody sign off, just to remind them of what's allowed and what's not allowed as your result, and making sure that employees don't retaliate, following up with employees. Go back to the person who complained and said, have you experienced any other problems? Putting an extra eye on top of that person's manager to make sure they're not getting discipline or extra scrutiny or anything like that. That's a key to helping alleviate any retaliation concerns. Michelle, you want to go to the next slide? It is important to communicate with the person who harassed, let them know how the investigation is going and where you're at with it. If it's taking a while, let them know that's been concluded. You do not have to tell the harasser how you dealt with, you don't have to tell the person who complained how you dealt with the harasser. You don't have to tell one employee the discipline of another. Maybe it was no discipline, maybe it was a written warning. That's not their business. You can say, we've handled it, we dealt with it. It won't be an issue again. If you experience any other concerns, bring them to us immediately so that we can deal with them. Obviously, if the person's fired, they'll figure that out. But you just want to make sure that you're communicating with them that you've taken their complaint seriously, you've dealt with it, and that they won't be retaliated against. Next slide, please. And then you can jump one more slide past that. So another option, another thing to concern yourself with is the external issues from a complaint. Sometimes we'll see these issues where the person it'll be pre-suit and they'll be threatening to file a complaint that embarrasses the company. And this can be anything, but we see it more, I think, in harassment than anywhere else. So give me money or I'm going to call the newspaper and tell them that I was harassed at your workplace. So, you know, in addition to your internal process, to the investigation, the documentation, stuff that you need to prove your affirmative defense, maybe you want this handled outside. Maybe you want it handled through a law firm that will have attorney-client privilege. Maybe you need a PR people to help if media statements need to be made. That you've taken proper action. That you know, one of the things we're seeing is social media posts that are offensive, and then somebody who's not an employee calls and says, "Your employee just posted this online. What are you going to do about it?" So maybe and then it becomes a news story. So maybe you need to deal with that. Just additional considerations, but the main thing is you get a complaint, you do the investigation, you document it, you take action. And then the last slide here, the next slide, Michelle, I think it's almost the last one. The de-evolution. So I've gotten this question. Some of my clients call it the Mike Pence rule or the Billy Graham rule. Man who can't be alone with a woman. You know, and his job is sales, or you know, and he says, "Well, I can't do this because of these kind of requirements." As far as I know, it's not a religious restriction. It's a social one, and can lead to women complaining, "Well, so and so won't go to a business lunch with me because of this position." And so you want to make sure you train and review and make sure that that's not a concern in your workplace, because that's something that could potentially lead to liability for a company. All right, so now the last slide. Take your head out of the sand. Like I said, you want these complaints to come to you so that you can deal with them, so that you can resolve the problem and try to avoid any legal liability for the business. So that's the main takeaway there. And I'm available, Matt's available, Ari's available. We're happy to take any questions at this time. Really appreciate everybody coming and participating.
All right. I'm going to stop share so I can see everyone and see the chat. Okay. If anyone has questions, let's see. I know, David, you were doing a great job watching the chat. All right. Are there any other questions? I just want to make sure everyone has an opportunity to ask a question before we go. Nope. I don't see any. So, okay. So with that said, David, thank you so much for your leadership and for a very, I think, informative and timely, relevant HR webinar. I always find these informative, and I always learn something new that I did not know. So thank you for sharing this information, your expertise with us. So thank you also, Matthew and Ari. And I know, I just want to, for everyone to stay tuned that, like I said, we do these quarterly. The next one will probably be in January, late January, early February timeframe. We do market these as a full series, so please stay tuned for our 2021, which I can't believe I'm saying. Is it really 2021? Coming soon, for our next topics for next year. So with that said, David, thanks again. Matthew and Ari, thank you. And thanks to FordHarrison for letting you share your time with us. We appreciate it. And we will talk to you soon.
Great.
Thanks to our guests. All right. Thank you. Bye, everyone. Have a safe day.